Ladies and gentlemen, I'm glad to be with you tonight. My name is Dick Bray, and I'm going to provide just a quick overview of the Brown Act, our California open meeting law. The Brown Act was authored in 1953 by Assemblyman Ralph M. Brown. It was passed by the legislature and signed by then Governor Earl Warren. In its opening section, it states, "In enacting this chapter, the legislature finds and declares that the public commissions, boards, and councils, and the other public agencies in the state exist to aid the conduct of the people's business. It is the intent of the law that their actions be taken openly and their deliberations be conducted openly." One of the provisions of the Brown Act relates to newly elected board members that haven't taken the oath of office yet. There's always a gap between when the county registrar of voters certifies a board member's election, usually in mid or late November, and when the board member is actually sworn into office in early December. During this gap, the board member is already subject to the Brown Act provisions. Board agendas have to be posted 72 hours before a regular meeting. In addition to the posted agenda, the board packet, with the exception of the closed session materials, needs to be made available to any inquiring member of the public. And when a handout is presented to the board at a meeting that has not been included in the packet, the public must be informed of its availability for their review upon request. The public is afforded time at all regular board meetings for comment on non-agendized matters within the board's jurisdiction at a specifically designated point on the agenda. Public comments on agendized items at all regular and special board meetings may be made before or while the item is under consideration by the board, but before the board acts on the item. The board also affords time for comment on closed session items before the board goes into closed session. The public comments portion of the agenda is not intended for the board to conduct a dialogue with the public. Rather, it's for the board to hear input from the public. Public comments should not lead to a board discussion or action on any matter not on the public agenda. Closed session items are the only items exempt from being open to the public. The Brown Act lists 11 very specific areas that may be discussed and action taken in closed session. They are conference with real property negotiators, conference with labor negotiators, conference with legal counsel on existing litigation, conference with legal counsel on anticipated litigation, liability claims, threat to public services or facilities, public employee appointments, public employee performance evaluations, public employee discipline, dismissal, and release, specific complaints or charges brought against an employee by another person or another employee, and last, student expulsion, unless parents request that it be heard in open session. Any action taken in closed session must be reported to the public in open session immediately following the closed session. Confidentiality of information, where applied, will be observed in reporting out any action taken in closed session. All matters discussed in closed session must remain confidential. The Act states, "A person may not disclose confidential information that has been acquired by being present in a closed session to a person not entitled to receive it, unless the legislative body authorizes disclosure of that confidential information. Violation of this section may be addressed by the use of such remedies as are currently available by law, including, but not limited to, 1, injunctive relief to prevent the disclosure of confidential information prohibited by this section. Number 2, disciplinary action against an employee who has willfully disclosed confidential information in violation of the section. And 3rd, referral of a member of a legislative body to the grand jury who has willfully disclosed confidential information in violation of this section. And 4 quick reminders for you about closed session. 1, do discuss only appropriately agendized matters. 2, do agendize only those matters that are exempt from being open to the public. 3, do not discuss closed session matters outside of closed session. And 4, do keep all confidential matters confidential. Board members need to hold themselves accountable for complying with the Brown Act, and the board as a body needs to hold each other accountable for staying within the boundaries of the Brown Act. The board also has a provision prohibiting serial meetings. A majority of the members of the legislative body shall not, outside a meeting authorized by this chapter, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. In this area of digital and social media, email, text messaging, and social media tools like Facebook, Twitter, Instagram, and others, and video conferencing programs like Zoom or WebEx are now common in personal and professional life. The digital trap for school board members is that an email reply to all, a retweet, or even clicking a like button could morph into a serial meeting violation of the Brown Act. School board meetings must be open to the public. Fair notice must be given in advance so that members of the public may attend and comment on agenda items and related matters. Electronic communications that circumvent this access, whether intentional or not, violates the Brown Act. This concludes the presentation. Thank you very much.